and you said you would go ahead and journalize that order?
Yes. I was going to ask, do you want me to do a hearing order or just the mediation order? I can do the
Just
hearing
a
order that has both.
mediation order.
This paternity action may sound routine, but with an 8-month-old baby at the center, emotions are already high. DNA confirms Joseph as the natural father, and now the real battle begins: permanent custody. Temporary plans, breastfeeding arguments, and 50-50 demands are colliding fast. Subscribe for more dramatic breakdowns.
This is a paternity action, and a petition for paternity was filed by Ms. Herman with regard to the minor child, Riley James Keene, whose date of birth is May of 25, so she's just months old. On September 10th of 25.
Hey.
And apparently she got a note from Dr. Roush that at least early on the child was breastfeeding and needed to be in the custody of mother. But at any rate, Ms. Orchard, is your client admitting that he is the father, as he is the presumptive father on the birth certificate?
Yes, Judge, and the parties did have a DNA test done as well.
Okay, so I will declare paternity that Joseph Keene is the natural father of Riley James Keene. And then I can't tell, Ms. Orchard, I think they were operating under this 9/11/25 temporary parenting plan, or at least that's the last, that's the only thing that's been approved by a judge that I can tell. The rest of everything is proposed. And it did give mother primary residential, with him having Thursday nights, and I'm not sure of the every other weekend situation. Can you, and there, I understand there have been some accusations that he didn't return the child in September and some other things, but after review of the case, where do you believe that we are at with regard to a potential permanent parenting plan?
Thank you, Judge. Yeah, so like you said, the child is 8 months old now, and they had been, I'm not quite sure, the temporary parenting plan was granted ex parte, which is not typically standard, at least for most of the counties that I practice in, to have that done in a paternity ex parte, only a divorce. But regardless, they have been following an every other weekend and Wednesday night type plan so far, because that's what has been allowed, and that was granted by the court. My client would like to have 50-50 on a permanent basis. So I don't know if we need to get a trial scheduled, but my client, according to my client, they did have an agreement to have equal time. And then there was the breastfeeding that happened. So then they made adjustments for that. But according to the pictures that everyone has sent in, the child is no longer breastfeeding. She's on formula and food at this point. So since that is no longer a barrier for parenting time, my client would like to have shared custody moving forward on a permanent basis. So that's where we'd like the case to go. To my understanding, I don't believe Ms. Herman is in agreement with that. So that's why I think we will probably just need to schedule the matter for a contested hearing.
Okay. And he has one other son, is that correct?
Yes, who lives with him full time.
All right. Sheridan, what about you? How many children do you have?
I have 4 total.
Okay, give me their ages and their residential situation, please.
Christopher C. High, 6, and he lives with me.
Full time?
Delaney, yes.
Okay.
Delaney Allen, 3. She lives with me full time. Riley is in the home. She lives with me and does the every other weekends and the overnight. And then Paisley Herman, she is 13, and she lives 30% here and 70% at my grandmother's.
Well, now we get my cupcake.
Okay. And are you still living in Butler County?
Yeah,
What's the distance between you and him?
about
I don't.
15 minutes.
Okay.
My son's not no bean.
Hold on,
I
please.
repeat this.
Did the two of you live together for any period of time?
No, I did let him stay at my house for 2 or 3 weeks after she was born. Hold on, please.
How long what was the duration of your relationship?
The first time we were together was like 6, 7 years, maybe. I don't know, but this time we were kind of just sleeping together.
All right. No commitment at all. All right.
No.
Okay. Well, I think we ought to at least attempt mediation or domestic conciliation. Miss Orchard, I will let you pick whether you want to start with mediation, or you don't think it would probably be productive and would prefer domestic conciliation.
I usually prefer to do domestic conciliation, just because, a lot of the times, if we're going to come to an agreement, we usually do before we ever go to court. So if we're here, I don't think that mediation, it's possible. I don't know, but I would prefer conciliation, Judge.
Okay. Do you know somebody over in Wichita that's maybe cheaper than Andover?
Oh gosh. Do you know how much the Andover Center usually is? I mean, I know of a few places.
Couple thousand.
No, probably not. They're probably all around the same, if not a little bit higher in Sedgwick County, I would guess. Is that a couple thousand for each party or total, Judge?
Each party.
Okay, yeah, it's about the same in Sedgwick County, a couple thousand for each. We could try, if we wanted to try something cheaper before doing that, we could always try mediation. And if that's not successful, then do conciliation with the Midland Mediation Center. I know they do a sliding scale based on income for that.
That's who I need an order for, is Midland.
Okay.
And I really think that the intentions of the Supreme Court when they created all of the domestic mediation categories, I still think they intended for folks to start with mediation and develop some skills and start talking about the situation, and then, I mean, ideally, and then domestic conciliation if necessary, if the court wants recommendations. What I'm going to need is either a guardian ad litem or domestic conciliation, where they do some legwork and background work and information, and just, and Andover is as thorough as any place. I would bet my money on it. It's very extensive, but it's not always affordable. And I want people to be able to feed their children. So I think probably Midland is where we'll start. And I think we should start with, and is that where Mediation Works is? At Midland, or is that different?
I think that's different.
Okay.
It's just
So
one
Midland
gal.
Does Midland let you go directly to domestic conciliation on a sliding scale?
No, so Midland will not offer conciliation. All she will do is mediation. So if we need conciliation later, we would have to do that with somebody else. she's not an attorney. That's why she's so cheap.
Right here, the judge draws a firm line. Mediation first, trial later. Instead of rushing into a custody war, she's forcing structured discussion about daycare, finances, bonding, and practicality. A March trial date is set, but she's clearly signaling resolve it now or litigate it fully. Will cooperation happen?
Okay.
But she does do a lot of custody mediation for Sedgwick County. And she's the only one I'm aware of that will do the income scale. So,
Okay. Well, for a while there was Mediation Works that was almost free with a grant or something, but okay. Well, let's try Midland Mediation. I'll go ahead and give you a pretrial and a trial date, but I want them to have a discussion about everything, who's working when, who's going to pay for daycare, who's going to be daycare provider, just overall what makes sense financially, allows both of them to bond, and discuss, the advantages of a primary caretaker or whatever the case may be. So, and talk about, let them sort of vent what their various concerns are and see where we end up. All right. Trial date. I usually give 60 days for mediation. In fact, domestic conciliation, I like that done in 60 days too, because I feel like if you can't resolve something in 60 days, you're probably not going to. And as time goes on, there are just more issues that develop if you drag it out. So that would be a trial date, probably in mid-March.
Eat it.
See here.
pretty open in March so far.
Okay.
Not at the beginning, but mid to late is pretty open.
How about the 24th, 25th, and the 27th of March?
24th, 25th, or 27th.
Yes.
Any of those days work for me. So if any days are better for either of the parties with work, I'm fine with any one of those dates.
All right. Well, unless there's an objection, I'm probably going to do Tuesday, the 24th, for an all-day custody trial if needed.
That will be in person, correct, Judge?
Yes.
Now, I do have a question.
Hang on just a minute.
Here, stay right here. Go eat your cupcake and sit down. Don't wait there for me either, please.
All right. And you'll do a mediation order with the information. It'll be up to each party to contact them and fill out their paperwork. We can do a pretrial conference on Tuesday, March the 3rd at 3:00.
Do that if it's by Zoom.
Yes.
Okay.
And so we'll definitely have to have a report from Midland by then.
You said 3 p.m., correct?
In case for trial, if you think it needs to be, or if you've worked something out after. I mean, sometimes they go to mediation, get some things agreed upon, there's some things that are left, come back to you, maybe get your advice of, kind of predicting what direction things might go with your experience in the court system, that kind of thing. Obviously, you can only give your client legal advice, but we'll just kind of see where you're at that day by Zoom. And then generally in the interim, what they've been doing, I think a lot of times we will do temporary orders for parenting, and not very many pro se ones with merge ex parte orders get submitted, but, we try to just adopt de facto what's been occurring. But at any rate, right now, that's the only order we have on file, which is giving your client every other weekend and every Thursday evening. And so that would remain in effect until trial or a permanent agreement between the parties. And so, Ms. Herman, what question do you have?
So you know how you said it's going to be in the courtroom for the next hearing?
Yes.
I won't have a babysitter for Christopher, so would he be able to come? I don't let that side of the family have him very often.
Well, do you have a friend or someone that could come with you and watch him in the children's room that we have, where we have books and toys and stuff?
Yes, they could.
Okay, just do that then.
Okay.
I know, Miss Orchard, you filed a proposed parenting plan, which is on file, Friday. And then there are some exhibits. Is there reason for me to consider the exhibits at this time? Other than you said, I guess there's not a breastfeeding issue. That's one issue that you already mentioned.
Right. No, Judge, the proposed parenting plan and exhibits are just, they were just with the intention of my client is asking to get more time, even on a temporary basis. But I understand the court's orders today are to keep the other parenting plan in place. So other than that, no, I don't believe there's a reason to address that today. They can address.
Go ahead. I'm so sorry.
It's okay. I was just say they can address his proposed plan and her proposed plan and all of that in mediation.
Yeah. And you said you would go ahead and journalize that order.
Yes. I was going to ask, do you want me to do a hearing order or just the mediation order? I can do the
Just
hearing order.
Mediation order.
Okay.
Since I didn't do any kind of modifications of the temporary, I don't think we need to do any journal entry.
Yeah, I was just going to do a journal entry decree of paternity
okay.
for him, and then just something that sets the trial dates out.
Okay, perfect. I'd appreciate that if you get a chance.
Okay. Yes,
okay, now, Mom and Dad, I need you to work well together with the current permitting plan. It will be very helpful if when you start your mediation, that you start on a good foot, that people are showing up when they're supposed to, they're on time. I suggest, if you don't like to communicate in person, that you get a spiral notebook with her name on it, and you pass that back and forth, and you can make notes to each other. Like, she slept all night, or she's getting a cold, or I'm taking her to the doctor, or whatever else. So you've got that documented, because if that doesn't work, then we shift to an application, like Family Wizard or one of those things that costs money for you to communicate through. And hopefully that isn't going to be necessary, but if you have trouble communicating, then at least send a spiral notebook back and forth in your diaper bag, so that you can make notes about various things and make sure that you don't forget to tell the other party. Okay?
Okay.
All right. If there's nothing further for today, we are adjourned.
In the end, the judge keeps the existing temporary plan and emphasizes communication over conflict. Spiral notebooks, potential parenting apps, and cooperation are now critical. The custody fight isn't decided yet, but behavior between now and trial could shape everything. Like, comment, and subscribe for more shocking courtroom stories.